Notice of acceptance of constitutions and of oath of office. Bigger instruction. The following. Welcome to the world of fiction. The United States government and the state government and all of their agencies and subdivisions such as the city, county, boroughs, and townships and banks are corporations. C. Corpus Juris Secundum, CJS, heading for government. All corporations are fictions or artificial persons created under the authority of the law. C. Black's Law Dictionary, corporations, and all such corporate fictions are established by a set of rules called bylaws. Public, government, corporations use the term constitution as the name of their bylaws, which are nothing more than an offer to the people of the forum the government intends to use to govern. Notice that their constitutions are generally amended internally as opposed to genuine government constitutions which are externally amended. If you will recall the history of the formation of the United States government, its bylaws, the Constitution, and amendments thereto were offered to the whole world, but only officially accepted and ratified by representatives of the state corporation governments, thus binding both corporate governments in a contract. The American private sector, although included within the offer, were never given the offer to officially vote for or against nor to make an official acceptance or rejection. Thus, no contract involving private Americans as a party to the Constitution exists. A contract, in the modern sense of the word, has been defined as an agreement containing a promise enforceable in law. The term agreement implies that there are at least two parties involved, since one party cannot agree to a proposition unless it is made to him by another party. The term further implies that one party proposed a promise or offer to which the other party agreed or accepted. Thus, an agreement is the result of an offer by one party and an acceptance by the other party, which creates a binding contract. A study of the law of contracts should be done by acquiring a copy of the law textbook called Farnsworth on Contracts, copyright symbol 2004 by E. Alan Farnsworth, 3rd edition, Aspen Publishers, ISBN 0-7355-4605-3, Volume 1. This book is the most comprehensive work on the relation between the law of contracts and the Uniform Commercial Code, UCC, but for now, the important part is the explanation of offer and acceptance at section 3.3 on pages 112 and 113. It explains that the offeror may withdraw the offer any time until the one it is offered to formally accepts the offer, and then and only then does it become a binding contract. Reread this till you get it. If you've been to court over any kind of issue, you have already seen that the Constitution is non-existent. A judge will tell you that Constitution doesn't mean anything in his/her court. The judge may even threaten you with a charge of contempt of court when you even mention the Constitution. An attorney lawyer will tell you that they don't use the Constitution, and the same is said by tax collectors and police officers. Well, they are just withdrawing the offer to you, the American private people, simply because we, the private sector, have never formally accepted their offer. Whether the offer is the United States Constitution or the Constitution of the state government corporation, aka the state, near where we live our private lives. Nor has the private sector ever formally accepted the oath of any government worker to uphold and defend the Constitution, which is required by the law, their law, upon taking office. It appears to be a must that we formally accept the constitutions as well as the oath of office of any public servant, i.e. government worker, that we may be forced to do business within their official capacity. To look at it in another way, consider that the public official is often referred to as honorable, i.e. the Honorable Judge John Doe. If one thinks about this for a moment and considers that perhaps we have been looking at this in a way that has not been to our benefit. If one is referred to as being honorable, may it not mean that it is up to someone, like you and me, to honor them, and should we choose not to honor their offer of contract, then why should they honor us? When we choose to honor someone's offering, do we not become the customer? And is not the customer king? The major reasoning behind the concept of a notice of acceptance of the constitutions and of oath of office is the protection afforded by the constitutions of the private sector's personal liberty and private property. In the history of the world, there has never been a better form of government other than what the constitutions provide for us here in North America. We might add that never throughout the history of the world has there ever been such corruption of the purpose of a government by a small group of greedy, self-serving people misusing the power of office as we have experienced here in North America. Our private property has been taken by forced registration and recordation into corporate government records, which casts upon the private sector an onslaught of corporate government regulations and taxation. If the state government or any of its political subdivisions calls to be registered or recorded anyone's private property and then invokes its powers to regulate and tax the private property of one of the private sector, such action is a violation of the Due Process Clause of the 14th Amendment, nor shall any state deprive any person of life, liberty, or property, without due process of the law. But wait, we are a party to the alleged constitutions, are we? What is the purpose of a, or any, constitution? Answer: to serve as an operations manual, operational guidelines, fines for those who choose to be public servants. Remember your sovereign status, your consumer status, and unless, emphasis on unless, you have opted into being subject to something the something doesn't have legitimate control over you. Contracts make the law, all law is contract. Consider the 13th Amendment. And here is the secret decoding: it really doesn't matter what constitution we're talking about. The question to whomever after duly look up, duly accepting their alleged constitution and oath to preserve, protect, and defend, so help me God, is there something by or through your alleged constitution that compels my performance? If yes, then please enter it into the record of this matter. If no, then what am I doing here? Is there some manner of contract that is controlling? Can they show that you knowingly, willingly, and voluntarily after full disclosure signed on to something that bears the other party's signature as well? C. Jurisdiction. FYI. Any elected or appointed official or attorney refusing to honor an acceptance of their oath is simply impersonating a public official and their alleged Texas Penal Code 37.11 impersonating a public servant, third-degree felony. One can also see 18 U.S.C. Sector 912, the 1st of March 95, Excite, Title 18, Crimes and Criminal Procedure, Part 1, Crimes, Chapter 43, False Personation, Head, Sector 912. Officer or employee of the United States. Statute. Whoever falsely assumes or pretends to be an officer or employee acting under the authority of the United States or any department, agency, or officer thereof, and acts as such, or in such pretended character demands or obtains any money, paper, document, or thing of value, shall be fined under this title or imprisoned not more than 3 years, or both. See this and this for more information. But anywhere along the way during an offer and acceptance situation there can always be a refusal, and a refusal does not constitute a refusal for cause or additioner, because you can't dishonor an offer, you can only dishonor a demand. You can't dishonor an offer. You may and you can choose to not honor an offer. You can refuse an offer, but you can't dishonor it. However, you can dishonor a demand. Once there's an offer and acceptance been made and then one of the parties demands their consideration and you refuse to give it to them, now that's a dishonor. You can refuse an offer and that's all you can do to it, or accept it. Now, if you accept it, according to the law books, you assume the liability for having accepted the offer. Whatever liability goes along with it, you've accepted it. One should decide whether or not one wants to assume that liability. In some cases you may want to, as it may be beneficial to you. Remember that a constitution is a limiting, defining authority device. Now go back and reread that a couple of times until you get just who it was written for. Challenge is not argument. Sovereigns, employers, grantors, principals, make demands. Demands are met or not met. Subjects, employees, grantees, servants, make requests. Requests can be either granted or denied.
Give thanks and praise to the mystic laws of the universe and its protective functions and forces in nature that guide our thoughts and our path in all ways that are lawful, correct, and positive. Give thanks and praise. I share this information only because when I will speak of certain things and it will fly over people's head or people will ask, hey, what talk about? Whenever I say when I go in a court, the moment me invoke their oath of office, it changes everything. Truly. Yeah, man. So we present this information as a form of confirmation that there is such a thing. So when you speak, you have to know where you are set. It's like having a key. If you don't have the key, you're not getting access. And the key are usually the esoteric information where them not bring forward mainstream. No attorney will teach you this. This is why when we go to any office, any agency, and the moment I step in front, whatever window it is, then I go face some kind of clerk. Usually, the very first clerk when I go face now can handle when I deal with because them now have that information. So the very first thing me ask them if them have a oath of office. Usually they say no. I say, can I get a supervisor who do or anyone who does? And then me proceed. I remember when me I do these things, these people totally unaware. Them probably I look for me like I'm from space or something. Yeah, man. However, with this is the approach. This is always the approach. The next thing, when it come on to contract, guys, only because, as I have said, from any corporate entity, send any presentment or any kind of correspondence, it's an offer to contract, really. And usually, when them get we in some of these contract, them always have with a sign right here, and we just say it's formality, with a sign, we don't even read, with a sign. Sometimes we don't even have to sign, it's implied by our actions. So them say, yeah, man, you're in a contract because this is what you do and how you do it. However, if we ask them for sure, where we as a people knowingly, willingly, and voluntarily, after full disclosure, this is the part where is interesting, the full disclosure part. Yeah, man. So if them can't prove, say, boy, we get full disclosure signed onto something that bears the other party's signature as well. Usually, you know, see another signature there. Usually, that's a sign on a piece of paper and that's it. It's just like when we show you a document what we get from our good brother Joel Jaguar C, and this is supposed to be an official court copy or court document, which is unsigned. So these are evidence of fraud, people. This is why you see me share certain information and share it a certain kind of way. All people need to do is do their own research. We are being duped. We've always been duped, and them want to continue dupe us. Yeah, man. Because them say we are fool. We're dumb. We will never be able to figure out, what's really going on. And them go as far as even say, even if one or two or a few of us figure this thing out, we will never be able to apply whatever we know or learn. Usually, they make the so-called money be an obstacle. And this is why when education is supposed to be free, it is not, and it's so expensive. Yet, when you do get that expensive education, you still are going to lack this side of things. So we share the basic information, talking about this world, fictional world, a world of fiction, while the earth remains the same, factual. So we choose to stay rooted on the foundation of the earth, not necessarily the fictional world. And if them even carry we in the fictional world, we might be in it, but we're not of it. So gratitude again, people. Basic information share. And we move according to how the ancestral spirit guide us, irrespective of how it is or what it is. Yeah, man. And we express ourselves that very same way. As our advocacy is freedom, freedom in him. Freedom in. So we have to choose to acknowledge and accept these officials, public officials, public oath made on the penalty of perjury. Yeah, man. So them cannot choose for wear the correct hat, because these people wear multiple hats. When I say multiple hats, I mean function in a different capacities. This is how they work. And if they can do it, you can do it also. And this is why I say I will wear multiple hats, function in multiple different capacities. That's all it is. So people have to choose to arm themselves with correct knowledge. Everybody want to talk about freedom, but people not necessarily want to apply themselves so them can choose to make the steps when necessary according to their situation. Everybody's situation is not the same. And from my basic observation, it is a process. But the very first and most important thing I would think is the cognition of who and what you are. Yeah, man. As the ancient would say, man, know thyself. Man, know thyself. So I think at the first place one would choose to start. Try grasp the concept for know who and what you are. If you want to function just on a physical plane, or if you want to apply yourself where you can try to function both spiritually and physically. Step by step process, people. A world of fiction. world of fiction.
The following is a quote from a book called The Constitution of the United States, Its Sources and Application by Thomas James Norton, 1941, America's Future Incorporated, publisher. In the Fifth Amendment, the nation is forbidden to deprive anyone of life, liberty, or property without due process of law, and here the like command is issued by the people to the state. In the beginning it was national power that was feared. Experience later taught that the power of the state also may be tyrannical. Due process of law means, said the Supreme Court in a late case, 1908, that no change in ancient procedure can be made which disregards those fundamental principles which protect the citizen in his private right and guard him against the arbitrary action of the government. Private property is taken for public use in opening streets in cities, in constructing railways and canals, in erecting public buildings, in laying out public parks, and for kindred purposes. The owner cannot be deprived of his property for such purposes by the state without due process of law, that is, without a full hearing and adequate compensation. Public versus private. The next subject of importance is to learn to distinguish between public and private. The term public, adjective, in common meaning is sometimes used to refer to the entire population. In the strict legal sense, the term public only applies to government, political, and municipal corporations and to no one else. Found in Black's Law Dictionary 6th edition, page 1195, defining private as affecting or belonging to private individuals, as distinct from the public generally, not official, not clothed with office. C. People v. Powell, 280 Mich 699, 274 N. K 372, 373. In other words, if you are not in, or of, any office or government such as public school teacher, administrator, bank personnel at any level, police, fire officials, or any type of city, county, state or federal government worker, military, in other words, subject to the U.S. Constitution, then and only then are you a private citizen and a part of the private sector. Conclusion. In regards to protecting oneself from abusive public servants, check out the your state laws on stalking and exploitation, as well as neglect to protect provisions in state law, upholding and enforcing the law by parties under oath of office, as well as Title 18 U.S.C. Section 1621 concerning the neglect to protect by persons under oath, and Title 42 U.S.C. Section 1986, wherein a person having knowledge of the law, the power to stop a wrong and the duty to prevent a wrong from being done is liable for any failure to act. Should they fail to prevent a wrong, having knowledge of the law, the power to prevent, and the legal or moral duty to prevent the wrong, which causes deprivations of your religious and or civil rights or liberties, suit can be brought for violations. Our safety, our liberty, depends upon preserving the Constitution of the United States as our fathers made it inviolate. The people of the United States are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert the Constitution. Abraham Lincoln. Bind down the public officials with the chains of the Constitution. Thomas Jefferson. Thought. Jurisdiction can always be challenged on the grounds that the Constitution states that all matters in law and equity must be conducted in an Article 3 court. If this court is not an Article 3 court, then the accused requests that the matter be transferred to an Article 3 court or dismissed with prejudice. Ask the judge if he has taken an oath to uphold and defend the Constitution. He has to say yes. If you ask the judge if he intends to conduct his duties in compliance with that oath, what can he possibly say but yes? The judge knows if the court is an Article 3 court, but he is hoping you will not understand this or how to force him to comply with his oath of office. Things to consider while pondering constitutional law. First, Capital M Article 1, Section 8, Powers of Congress, to define and punish piracies and felonies committed on the high seas, and offences against the law of nations Article 6, Section 2, this Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding.